Today, Karen Reed's civil defense team tried to convince the judge to dismiss some of the claims that the plaintiff brought against her in the wrongful death suit. Here's what you need to know. So last year, prior to the second criminal trial against Karen Reed, the estate of John O'Keefe filed a civil lawsuit against her. That included claims for wrongful death as well as a negligent infliction of emotional distress. That litigation was stayed. What does that mean? That means that the judge in the civil case said, okay, while we have the criminal trial ongoing, there's still a lot of moving parts, we're not going to really do anything in the civil case. So we're going to put it on pause until the end of the criminal case. As many people know, the criminal trial ended after a jury trial with a verdict of not guilty on everything but the operating under the influence. What does that mean? That means now we revive what was paused in the civil trial. Today was the first in-court hearing date. We saw many of the lawyers for Karen Reed, as well as the Buzz C.F. McCarthy's, Waterfall, and of course the estate of John O'Keefe. What the purpose of today's hearing was for was to kind of see, where everybody was, what the discovery schedule looks like. We heard for the first time from defense counsel for Karen Reed that they intend on filing a motion to ask the court essentially for permission not only to file claims against the Alberts, the state police, the Canton police, Michael Proctor, Brian Tully, Yuri Buchanan, but they're also asking to essentially assert them in this particular wrongful death claim. And that's sort of a can of worms in and of itself. The court was not prepared to hear the motion because it has not actually been filed and was not provided to a defense. So that's an issue that we can see coming up in the sort of maybe coming months, that there might be additional claims. The question will be, can this be consolidated for all purposes? Can this be consolidated just for discovery? I think there is an argument to certainly having the discovery be done together, but I'm not sure that the ultimate case needs to have all the claims in one. What we did here was the motion to dismiss that the defense team filed, in which they asked the court to dismiss the claims of negligent infliction of emotional distress. So essentially what their argument was that these claims are subsumed by the wrongful death statute and are essentially duplicative. I will say, in terms of the presentation to the court, I felt like the plaintiff, who was arguing in defense of the motion to dismiss, did a better job. The counsel for the defense, Karen Reed, it was very short, it was very concise, and not super persuasive from my perspective. I think that plaintiff's counsel was much more prepared and had sort of this entire presentation of all of the counts to go through. So it's important to remember that in a motion to dismiss, we are at like the very, 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 very lowest standard, okay? And as we talked about in the motions to dismiss in the criminal case that were denied, the standard is very similar. So the court looks at the facts of the allegations in the complaint filed by the plaintiff, and he has to accept those facts as true for the analysis of the motion to dismiss. And he is to view those facts in the light most favorable to the plaintiff here, who is the estate of John O'Keefe, much like it was the Commonwealth in the criminal trial. I think it's unlikely that the plaintiff will succeed on this motion to dismiss, but there certainly is a possibility, and I think an argument was to be made. Most importantly, what we should take from this hearing was Judge O'Shea at the very end. And what he did is what many judges do when they see cases that they know should resolve. And they know they should resolve not only based on the underlying facts of the case, but what is to be anticipated down the road. And a lot of times what judges do in these cases is they basically give a spiel. And the spiel is not really for the lawyers. It's a little bit for the audience here because he knows everybody's watching and he was explaining what was going to happen. This was really for Karen Reed and the O'Keefes and also the Baz, in a secondary way. What he was saying to them is, this is going to consume your life for the next, 5, 10, 15, 20 years, realistically. That's what civil litigation is, especially when it's very, very litigious. Like we're fighting scraps here, scraps there, scraps that. because even at the end of a jury trial, which will take years, at this rate, we have a 2027 jury trial date. It's likely to probably be pushed further than that, given the fact that there is going to be so much discovery and so much litigation back and forth. So we're talking 3 or 4 years until you get to a jury trial. And then when you get a jury trial, there's a likelihood of appeal going all the way up. And it's money and it's time and it's hanging over your head. And basically what he said is, if I was plaintiff's counsel, he's saying this isn't talking to the O'Keefes. He's saying no amount of money is ever going to bring him back. Okay, so remember that in the back of your head. Remember that in the back of your head. And he said to defense counsel, when he was talking to Karen Reed, he said, remember, you have the, possibility of having an enormous judgment that will consume your life and sort of control in which way you move if it does go in your favor. And that's what litigation is an unpredictability to it. And so, in the interest of resolution, he sort of made the pitch and said, I'm sure that nobody is going to, I'm sure nobody's going to listen right now and that it's not going to settle. But based on my experience on the bench, based on how I know these cases go, I think it's something that everybody should seriously consider. So we are scheduled for a November 21st status date. At that time, we should have the defense motion to, we'll have the decision on the motion to dismiss. I think that's likely to be denied, viewing the facts in the light most favorable to the plaintiff. And then we're going to have the filing of the motion to request the court's permission to file claims against them, because so it's a sort of a complicated, they're almost separate claims. They're not defenses. You can't bring a claim against somebody else in defense of the claim of the wrongful death lawsuit. It's really a separate third-party claim that they're going to ask all be litigated together. And that's why I say I think there's a chance that they consolidate it for discovery purposes, which means that, we don't have to take 17 depositions in 17 different cases of the same people. We can all do one deposition, but then when it comes time to, actually litigate the substance of the claims, because the claims against Canton Police really don't have anything to do legally with the claims that the estate of John O'Keefe is making for wrongful death against Karen Reed. So I hope that helps. November 21st, we'll be back for a status conference on the motion to file these cross claims, as well as picking a trial date and figuring out the discovery. So make sure you come here, follow all your legal updates.